The existing torts weren't able to capture her experience, and her experience couldn't be slotted into those existing categories. So Justice Mandani did the right thing and granted her a workable remedy. That recognition from our highest court that the pain that they have suffered and are continuing to suffer in many cases, that it's real, that it happened, that it's wrong, it hurt them, and that they are entitled to compensation, to recognition of that pain.
One Great Case, a podcast about law to learn more about people. I'm your host, Areta Lloyd.
So let's talk about the case. I mean, why don't we start with the facts as they were?
Well, I wasn't involved at the trial level. We only come on the case at the Supreme Court of Canada level. So in terms of the facts, Kuldeep Ahluwalia and her husband come to Canada from India in the early 2000s. And the husband was abusive from the start of the marriage. He insulted her, he belittled her, he physically assaulted her. She endured a hard beating that left her black and blue. She told her mother about the violence, and her mother said that she should stay quiet, stay happy. So she was really isolated from her family in India. She was isolated from her friends. She wasn't allowed to sit at the table when there were friends over with the husband. So she was really controlled, limited, denied her autonomy. She was discouraged from pursuing employment and vocational training. She didn't have access to money. She was subjected to long periods of silent treatment until she submitted to his sexual demands. He assaulted her on multiple occasions, strangled her, threatened to kill her. He would yell at her when lunch wasn't ready. She had to get his consent to leave the house. He threatened to leave her and the two children penniless. And then she defies him by going to India, and he closes all of the parties' joint accounts, the credit cards. She's unemployed. She has no money to support herself and the children. And the husband starts litigation looking for the usual family law relief. She brings her own claims, and then she doesn't have money for counsel. And she winds up doing this 11-day trial, self-represented, where the husband has counsel, and she gets cross-examined with all of the myths and stereotypes that attach to family violence claims. She spends hundreds of hours preparing her own case. And then, she doesn't know how to plead a tort, but she does bring a claim for damages for physical and mental abuse. And then Justice Mandani, who's absolutely a trailblazer and who did a fantastic job in this case. She looks at the facts of the case and recognizes that damages for assault, battery, and intentional infliction of mental distress don't capture the harms that Kuldeep Ahluwalia endured. So she crafts the new tort. She named it Tort of Family Violence.
Right. But she said she would have awarded damages under the torts of assault and intentional infliction of emotional distress. So the question for you is, judicial activism, yes or no?
No.
I think people would disagree, but explain.
Well, she's hearing a family law case, and she has to do justice for a self-represented litigant who's endured horrible abuse. And we know from the larger social context that family violence victims are disproportionately women, overwhelmingly women, and very often racialized women who experience other intersecting grounds of discrimination. And so we had to make sure that the damage is specifically and fully compensated. The existing torts weren't able to capture her experience, and her experience couldn't be slotted into those existing categories. It was the cumulative harm that offended her autonomy, her dignity, that subjected her to this utter subordination. And so Justice Madani had to recognize with new language an incremental progression to tort law that's specifically situated in the family law context, where the vast majority of litigants are going to be self-represented, are not going to have access to like the proper language and all of the intricacies of tort law. They're just doing their family law case. They're trying to get by to protect themselves and their children and to have enough money just so that they can create a new life for themselves. So Justice Madani did the right thing and granted her a workable remedy.
The dissent, it seemed quite strongly written. And, without me taking sides about where that's going and what was said, they did note, to your point, that there are cases, there's a history of cases where the facts also are similar. Decades of emotional, physical, sexual abuse, manipulation, control. And the cases recognize that there's a pattern of abuse and its effects. In some cases, the victims were compensated more generously, I think, than Mrs. Ahluwalia. So where's the where is that bridge? Like, explain where that bridge is to a new tort.
So we have now recognition about the specific breach of trust that happens in the context of a spousal relationship that's really very different. So we had scholarship as part of the Supreme Court of Canada hearing that there's a family discount that was being applied in cases of intimate partner violence, where if you got punched in the face by a stranger, you would get better damage awards than if your husband punched you in the face. But it's not just about the quantum of the damages, it's about the quality of the harm, the nature of the harm, which is really specific in the family violence context. So with intimate partner violence, after you are harmed, it's not like you get to leave and go home to a safe space. That is your safe. That's supposed to be your safe space. So it's a totally qualitatively different experience. And so it was necessary to have a new tort to properly recognize this breach of trust that occurs in the context of intimate partner violence.
Yeah, there was quite a bit of part of the decision devoted to that, actually. And I thought that was really well explained by, I don't remember which judge wrote the for the majority, but I like, yeah. And I suspect that when we have a new tort, this also assists with, the police, if there's going to be calls, because as you said, there's a qualitative difference and there may indeed be a discount, especially for women. Can you talk a little bit about the gender part of this?
So it has been really clear for a long time in government reports, in Supreme Court of Canada cases, that intimate partner violence is gendered. And there was unanimous agreement by the Supreme Court of Canada that intimate partner violence is gendered. So there's not really any controversy here. It is true, it's recognized that there are other circumstances in which there may be intimate partner violence. And it's always a question of looking at who has power in the relationship. So it's not just about gender. So there's race, there's recent immigrant status, there's indigeneity, there's disability. So looking at all of those intersections is also really important, but it's about this removal of power, autonomy, and dignity and equality within a relationship. So it's going to be most often, in most cases in the family law context, it's going to be a husband and a wife, and the husband as the perpetrator of abuse. Not necessarily in every case, but we have to understand intimate partner violence within this larger social context of power in which women are disadvantaged.
And can you take me through the elements that family law lawyers are going to need to understand and to prove to make out intimate partner violence successful?
The Supreme Court of Canada has sent out a 3-part test for the new tort to determine liability. So first, the conduct has to arise within an intimate partnership or its aftermath. So an intimate partnership doesn't necessarily have to be marriage. And we're also looking at its aftermath. So the court has recognized that coercive control can very much be ongoing post-relationship. In family law cases, we see a lot of litigation abuse. We can see in an ongoing way, potentially for years, ongoing coercive controlling violence.
What is coercive control?
So coercive control was first articulated decades ago. Evan Stark set it out, and that work has been furthered by Dr. Emma Kapp. Coercive control is about removal of a person's autonomy and dignity and enabling the repression of a partner's will and ability to pursue their own ends in life. So we have Kuldeep Ahluwalia, who can't pursue employment, who can't interact with her family and friends. So coercive control is that removal of a person's own personal power and ambitions. It has to be an intimate partnership. Then it has to be that there was intentional coercive control. And then there has to be viewed objectively that the conduct amounts to coercive control.
You said that their coercive control is recognized before. I feel like this is really a huge step forward, that somehow it brings together a number of factors coalescing into this new tort. And I realize that some critics who feel that the court didn't go far enough, and we can discuss that in a minute, but it feels like a gelling, and I think it was meant to feel that there's a path forward for relief.
Absolutely, I totally agree. So we did have in the Divorce Act in 2021 amendments to recognize family violence. And that was in the context of the best interests of the child test. And in the definition of family violence, we had the language of coercive control. And that was 2021. It's a while ago, but it's not as though family lawyers necessarily embraced doing family violence screening and really started doing tort claims. I've talked to many senior practitioners who said, this doesn't come up in my cases. I don't quite understand that because the statistics would show that there's a lot of circumstances of intimate partner violence. This is not rare. But yeah, since 2021, we've had this language of coercive control in legislation. And now we have talk of criminalization of coercive control. There's been all kinds of international activity with respect to understanding intimate partner violence and coercive control. We had all kinds of scholarship around family violence and its harms. And so, yeah, it definitely was coming together that I wasn't surprised when we got leave. A lot of people were. I wasn't surprised at the results. A lot of people were. There were a lot of naysayers. But yeah, it was the right cultural moment. And it's a huge breakthrough for survivors of intimate partner violence. Absolutely.
Yes, I pulled a little snippet from the decision where the court says it's the concept of victims deserving a return to a fuller state of safety, freedom, and equality, which is not part of what existed. And it seems monumental.
It is monumental. Yeah, it's fantastic. And, there's a lot of family lawyers who are deeply concerned, and there's a lot of talk about potential lawyer negligence, and this gets lawyers understandably upset. But yeah, no, it's fantastic for our clients who are survivors of family violence. And it just signals this complete culture shift of recognizing the seriousness of family violence, understanding the harms of family violence, and for all of those women's organizations that intervened in the case of the Supreme Court of Canada, all of the women who have accessed those survivor organizations, just that recognition from our highest court that the pain that they have suffered and are continuing to suffer in many cases, that it's real, that it happened, that it's wrong, it hurt them, and that they are entitled to compensation, to recognition of that pain. Very powerful. And even if there isn't money there at the end of the day, for so many people, so much of court is just about telling your story and feeling heard. And the Supreme Court of Canada heard women, heard the pain and the suffering of those women, and said, you deserve compensation. It's very powerful.
Yeah, it's true. I actually wanted to ask you about compensation and damages. There's some criticism from the minority about damages. I think, there may be some more work to be done in this front. And I'm wondering what you think about that.
Well, we'd already agreed to the quantum of damages by the time we got to the Supreme Court of Canada. So we don't get from the court clear guidance about what the number should be, except that it's unanimous that awards generally have been too low.
I agree with you about that.
So then I leave it to, we'll have further conversation with civil litigation colleagues, but this is specifically a tort that we should be bringing in family law cases. So let's then, choose those really good example cases which exist in the civil litigation context. And because this is more serious, let's just increase the numbers there and get really good awards where there is property. In so many cases in family law, we've already got equalization of net family property for married couples, and we have equitable claims for unmarried couples in Ontario. So there's only so much to go around. But because this is supposed to survive bankruptcy, and because it's about recognition as much as it is actual money, I think it'll be very powerful to have these much higher damages awards being awarded.
What do you think about, I don't know if you read it, Jeffrey Carpenter, who acted for the respondent, has said he thinks the practical effect will be more modest than either supporters or critics believe.
I think that we're trying to have the family law bar be encouraged and stay positive, that this is something that can be incorporated readily into practice. And it's very much the culture of family law that we're supposed to settle our cases and resolve things expeditiously and cost effectively. And so Jeff was saying that he acts as a dispute resolution officer, and he had cases before him that related to torts, and he was able to settle those post Ahluwalia because this just changes the conversation, the negotiation, and it's going to improve outcomes for survivors. That doesn't necessarily mean the floodgates are opening and we're going to have all kinds of family law trials that involved damages claims.
I mean, to a certain extent, you really have to look for the right cases because, it's the same with any area of law. Most cases settle, right? So it's really hard to make new law. We really have to be activists in some way to shepherd a case from trial to appeal and make law.
Well, and in family law, we've got so many self-represented litigants. I think it's over 70% in Toronto.
That's pretty shocking.
Yeah. Mm-hmm. And even the people who have a lawyer at the beginning of a case, they're not very often able to keep paying that lawyer. And so it's very difficult for people to continue. I think the statistic is something like 4% of cases where litigation is commenced in family law wind up going to trial. And I think that's not just because we have a culture that is geared towards settling. It's because very often claimants don't have any real choice. They're just worn down. They're worn down before it even starts, that they're fearful of commencing the proceeding. They're worn down by not having access to money. We have huge problems with getting disclosure to get a child support award in the case. Even if you get an order for child support, family responsibility office often doesn't collect. So we just have all of these survivors who don't have access to money. They know how difficult the case is. They're not getting support from a lawyer. There's so many limitations on legal aid. And so it's very hard for anyone to get to a trial, let alone what Kuldeep Ahluwalia did, get all the way to the Supreme Court of Canada.
So what's your advice to family law lawyers now in the post-Ahluwalia landscape?
For every family lawyer, it's imperative to do proper screening for intimate partner violence. And after I just said that it's unpleasant to be told about negligence, we must talk about negligence. It is an obligation. It's part of professional competence to make sure you screen in every single case and really have these long conversations. It's a difficult conversation, and it's not a conversation where survivors are necessarily going to disclose immediately. So you have this ongoing obligation of screening, and you have to have people feel comfortable to share these really intimate stories about what their relationship was like. So for family lawyers, we've got to screen, we've got to have resources. What survivors really care about is access to referrals. And then make sure that you can keep your client safe, which you want to have relationships with survivor organizations, so that you can do all that you can do to make sure that you're still going to have a client the next day. separation is the most dangerous time for survivors of intimate partner violence. And, there are family lawyers who have had their clients killed. There's family lawyers who themselves have experienced violence. Family law is really difficult. It's difficult emotionally, but even more difficult in the circumstances of our clients. And practicing family law is really difficult, really important, but it's a joy to be able to help people, to hear their stories, and sometimes be able to assist them in having that story heard. And sometimes, in very special cases, actually being fully and totally recognized and the seriousness of the harm that someone has suffered, that actually being believed and achieving compensation.
Yes, it's pretty remarkable that Mrs. Ahluwalia was such a good protagonist, and good for her. Well,
there's a lot of survivors out there who wouldn't have had the, I don't blame them. Like, it's so difficult. It's remarkable what she did.
Well, thank you so much, Joanna, for speaking with me today. I really appreciate your time. For any family lawyers who want more information on how to proceed with this new tort, I will do a preliminary announcement on behalf of the TLA. There will be a practical course. I believe that's going to be held in the fall with a torts focus. So stay tuned, folks. And if you're not a member of the Toronto Lawyers Association, sign up at TLA.org. Thank you.
Thank you.